Hey folks, Greg Siskind here. I'm joined by Aaron Hall. I am not doing a Siskind Sussor live stream tonight. That was last night, and Elisa Taub and Robbie Rubin from our firm did a great job with that. I was at a basketball game. I went to see Vanderbilt play University of Memphis, two teams I love, but I love Vanderbilt just a little bit more on there. It's my alma mater, and I was not going to do the live stream last night when they haven't been here in like 20 years to play, and it's probably been that long since I've been to a Vandy basketball game. So they won in overtime, and I don't regret it that I went to that game. So that's why I wasn't here last night. But I did tell you yesterday that I was going to be here tonight because we were going to have some news, and I've been kind of teasing it for a while on our live streams that there was going to be some news in the Global Nurse Force H-1B case. We're going to talk about that in a minute, and you can actually see on your screen what you can find in Pacer tonight about our case. And then Aaron and I are going to talk about some really important new cases that we are working on, and then we'll do a little updating on some of the other cases that IMMpact is already working on that have already been filed in different places. So we're going to do the whole thing in an hour. And I hope that, and you're welcome to ask questions. I will tell you ahead of time that there are some things that we're going to not be able to answer, particularly about the H-1B case and strategy and things like that, and what's coming. And there are things that there are motions and things like that that are coming. But we can talk about what was just filed and give you sort of a general overview. We have co-counsel, and we have to behave as far as like what we say. And so we're going to be we're going to be a little circumspect about what's happened, but and we can also talk a little bit about the at least the two other cases that have been filed not by us but are on the similar issue, and maybe how these cases fit together a little bit. So Aaron, we have behind the scenes the IMMpact lawyers, as well as our friends, our co-counsel at Democracy Forward and at Justice Action Center, and at Cohen Milstein, which is a new to the team. We filed an amended complaint today in Global Nurse Force, the H-1B $100,000 fee case. This was this was a long time coming, but basically one of the chief goals of today was to transform this case into a class action, and that happens with the addition of new class plaintiffs or class representatives, particularly for employers that have joined the suit. There were three employers that are now a part of the case. One is, I will show you on here. Hang on, sorry. Where is it? Oh, Nephrology Associates of the Carolinas. This is a physician practice that does kidney dialysis and all kinds of things the nephrologists do, and they serve rural North Carolina. Really happy to have a healthcare employer, physician employer on the case. The second is BAE Industries in Michigan, and they are a manufacturer. And then the third that we added was Lower Brule Day School, which is a school district that is part of the Sioux Indian Nation in South Dakota. So we're thankful to our class plaintiffs that they have taken this task on. We think that the addition of these new plaintiffs strengthen the case, and there will be more filings coming shortly in the case. But the key on it is that by doing this, our aim is to make sure our relief benefits just about everybody that's impacted by this. And that's important because the other two cases that have been filed, and I don't speak for those lawyers, but those two cases are really important cases, but they don't do the same thing. So one of the cases is U.S. Chamber of Commerce versus Trump that was filed in D.C. They had some significant movement in their case, but basically they're further along in terms of the briefing. But Chamber of Commerce joined with the University Association, National Association of Universities. I always forget the name of their association, but basically it's all the colleges and universities in the country, and the Chamber of Commerce are in that case. That case was the injunction was, I believe, converted to a motion for summary judgment, and that's what has been briefed, and that is this document, I believe, on here that is in that case. Today, the government filed the last of the motions for regarding the summary judgment. So now the judge, at any point now, can make a decision. We don't know when. Could be very soon. There are rumors out there, but I don't want to speculate on that. But we could see a decision pretty soon in that case. But keep in mind that they have not asked for universal relief in that case. They are asking to benefit the chamber. It would benefit the Chamber of Commerce members, and it would benefit the University Association members. So that's a lot, but it just generally tends to be large corporations that tend to be Chamber of Commerce members because it is not inexpensive to join. And I don't really know. I've heard numbers that are quite large that it takes to join the Chamber of Commerce, and I suppose anybody can join it if they want. But they may find that there's not a big savings between that and the $100,000 that they would pay for an H-1B. Nevertheless, it's really important that they win. It would obviously, have a positive impact on the other cases that are out there. We're wishing really good luck to the legal team on that case, and hopefully we'll get some good news soon. And then we have another case. I don't know what it's called, Aaron, but this is the state attorneys general filed I think there's 17 of them, and they filed a similar case in Boston. So there's the Boston case, that's the state governments. There's our case, that's kind of like everybody. And then there's the chamber case, which is chamber members and universities, and that's in DC. Our case is in San Francisco. The state government's case just got filed a couple of days ago. So it's going to be a while probably before there's anything going on in that case. Aaron, you and I were just talking about the government's response, like this was their final basic arguments in this case. I wasn't super impressed with them. Obviously, I have a bias, but I will just tell people the government is arguing a few things that are a stretch, I think, like that they are saying that the concept of consular non-reviewability bars a judge from making a decision in this case. And basically, Aaron, do you want to explain what consular non-reviewability is and like what it's supposed to apply to?
Sure. Before I do that, I'm going to just address a couple of comments. There are a couple of people asking if we're going to talk about new litigation, including the
Yes.
39 countries litigation. We are. That is on the agenda.
You have to wait.
And then my other thing that I wanted to mention was I see one person who said that they're still subscribed from the Go litigation. So that's a good shout. That's a good callback. So
that is
nice to see you.
Well, you know what? What's old is new again on there. Some
That's
of the
right.
issues, a lot of the issues that we thought were over in that case are brought back to life with the new.
That's right. So consular non-reviewability is basically the doctrine that says that courts are not going to re-adjudicate or even entertain the re-adjudication of a consular decision on whether or not to grant a visa.
Mm-hmm.
But does that mean that they're not going to look at a policy that, for example, bars the issuance of visa across a group or a class. And what do you say to that, Greg?
Well, that's the distinction on there. Consular non-reviewability is supposed to basically prevent a judge from looking over the shoulders of an individual consular officer that's hearing all the facts and basically has to make decisions quickly, applying the facts to the law and making decisions on cases. And that is something that Congress decided was that they didn't want to interfere with that individual decision making, although you can still have some review if they've made a misstatement of the law. They're just not supposed to be reviewed as far as applying facts to law. As that's my understanding, is that if there's something that's a strictly illegal application of a law, that you might even be able to make an argument there. But that doesn't even matter here. Even if I'm wrong on that interpretation, it doesn't matter, because the issue here is that this is a policy that's being dictated from the White House upon that they're forcing on consular officers, and that is not what consular non-reviewability is about. So I think that's a loser, and I think the chamber is going to win on that issue. We make similar issues in our case. There's a lot of overlap between arguments, because they're good arguments, and that's why the chamber made them, and that's why we made them. So the government, I think, I don't think that's going to be a winner for them. They also are arguing that let's see what they had on here, that we're arguing that the statute itself bars basically sets Congress basically has authority to shape immigration policy and the immigration system. The president has some ability under 212F to bar a group of people from entry to the United States. But as far as how the visa system works, how the administration of the immigration system works, he can't just change the whole system for how our immigration system works, because he doesn't like the types of people that the visas are intended to benefit. So he can't basically say, Congress, I don't like this visa program that you created. I don't think these people should be allowed to come into the United States because I think this visa program is a bad idea. That's essentially so he's basically vetoing legislation from Congress and saying he has that authority under 212F, which, keep in mind, 212F, when you can bar an individual or group of individuals, has never been stretched to basically say entire programs that Congress created that were deemed by Congress to be in the country's interest are invalid across the board. 212F was, up until the first Trump administration, was basically used for a couple people here, a couple people there. It was never like designed for these across the board policies the way they're being used now. And this is a big stretch what he's doing now from the Trump v. Hawaii case, which was the Muslim ban, the first go around, where they had it was considerably narrower as far as who was covered there. Now we're talking, an entire visa category for the entire world. It's not it's not a sort of a narrow group. Maybe if he said a particular kind of, maybe he said we don't want certain nuclear scientists coming into the United States who, or whatever. If he had sort of like a group for national security reasons that he didn't want to give H-1B visas to, maybe, but I don't think you can do it this way. Anyway, that was another argument. They had, let's see, they made arguments against our APA claims. I'm not going to spend a lot of time talking about what the government said here. You can read. I'll probably post this at some point on LinkedIn or on X or a few places so people can read for themselves. But I think it's a strong case, and I will and I am very hopeful that this first decision that's going to probably come in the chamber case very soon is going to be one. I think it's going to be a good one, but we will see. Aaron, anything else we want to add about the H-1B litigation?
No, I think we're just, I've been. I was telling Greg. I've been watching and chipping in a tiny bit at the beginning, but not really. I've been watching Greg and Chuck and Zach from our office, and then the lawyers at Democracy Forward and JC and all the other lawyers, and it's just been such an incredible effort, and we're so thankful for the new class representative plaintiffs and I just think that the case and the work has been incredible, and I'm feeling very positive about it. So,
All right, and I will probably post our amended complaint as well at some point. I don't know if it'll be tonight or tomorrow, but at some point that it's going to be coming. But basically, it's this. And those of you who are the lawyers out there are resourceful enough to be able to figure out how to get things off of Pacer. The case is Global Nurse Force versus Trump. I think it's versus Trump on here. Yep, it's Trump. So that's the update on that case. Aaron, before we get to the new cases, I did think it would be good probably to review a couple of the other ones that are pending. So we have you want to say a little bit about what's happening on our student case? That's the sort of the sequel to the Georgia case that we had with the initial students with the CVIS terminations. Now we have a subgroup of that group that we are seeking to have their visas reinstated. So that's that case is. You want to say anything about that, or you want me to?
No, I mean it's just you get the government to or you get a court order saying that they can no longer terminate somebody's status without any real reason or basis, and then they still fight you on reinstating the visa. To me, it's crazy that this has to go to litigation, but we are certainly excited to pursue it because it's ridiculous. So.
Yeah, I mean, they basically admitted that all the people that were in our group were falsely that they were falsely accused, or they have, that they were not. There was no basis for removing their for terminating their CVIS and impacting their ability to maintain student status. So there's really no, if they've admitted that, one agency has admitted that, so it's hard to understand why the Department of State thinks they have an argument that after the other agency admitted basically that they that none of these people engaged in conduct that would justify terminating them as CVIS, why they still haven't fixed the other part of it. And it does get back to this consular non-reviewability question, where the government is basically saying the State Department cannot be. It doesn't matter that that whether they're right or they're wrong, they just can't be subjected to any kind of judicial review on there, and that's a key issue that we're challenging in this case. That this was a policy that was initiated in Washington and imposed on consular officers, and it's a similar issue that the government's a similar argument they're going to presumably make in this case that they made in the that they just made in the Chambers H-1B case, and presumably they will as well in the Global Nurse Force case as well. But they are arguing that consular non-reviewability essentially takes all the power away from judges to address illegal conduct, and we are saying that the law still matters. Okay, we had we also have there's a second a second student case, but this was for Iranians. I don't know if you are involved enough in that case, but I'll leave that one probably for Chuck and Jesse for the next one. And the only other thing I think, aside from the two that we're going to mention that that are onboarding, is the last one. Was that the Ukrainian case is still kicking around. I should say we've won most of that case over the last couple of years, and this is the one about first about getting them authorized to work incident to status. We succeeded on that case in late 2022. We also succeeded in a second case in getting the government to admit that they had to issue fee refunds. they issued a lot of fee refunds, and then they basically said, well, we're doing it, but we're not doing it for this group of early people who came in parole status. And so that's where the last of the fight remains. And so we're still working on that case after a couple of years, and its filings are still happening. We thought we were done, and then the election happened, and the administration decided that they're not done with that issue. So we're still fighting with them over that. So those are the the cases that we have in the works right now. But we have two important cases. We have a case on U&T visas, and that is that I know a lot more of you are interested in. That's why we're saving it for last. You're interested in the other case, but the U&T visa case, it's a really important one. I don't know if there are immigration lawyers that are watching us right now, or may be watching the recording, but a lot of you represent people that are in U&T status. Part of the U visa, U visas are for crime victims, and T visas are for trafficking victims. They're similar. But basically, in those cases, there are limits on the numbers of people that can actually get them. So there reaches a point in the case where the government has said you qualify, but there's no visa numbers available. Aaron, is that a correct way to characterize it?
Yeah. So, for example, for the U visa, they can only grant 10,000 per year to principal applicants, and there are far more that apply every year. And so this big old backlog has formed over the course of years, and now it takes, I don't know what they're estimating anymore.
But when you get to that point, then they will grant you something called deferred action, which allows you to remain in the United States and get work authorization and avoid deportation while you're waiting ultimately for a visa number to become available. And that's sort of a practical way that it's been dealt with. And unfortunately, ICE has not been honoring those the deferred action, and people have been are growing increasingly concerned that they're going to go after U visa holders in a bigger way. What we're seeking in this case is to get protection for plaintiffs from that happening, and basically preserving their deferred action by a court order, so that they don't just get put on a plane and sent abroad, even though they have have deferred action and have a case that's essentially already been approved by the government, but for waiting on those numbers to become available. So that is if you're a URT visa holder, and I suspect there's probably not that many that are watching, but if you are a lawyer that represents people in those cases, please go to IMMpact Litigation. I'm going to, in a second, Aaron, put actually, I'm going to take off this share screen, and I'll put on in a second what our address is to go look up that case. But that's an important case, and I know we all need to. I thought I had IMMpact Litigation. I'll make a new one, but that's that case. Now we can talk about the case that I know people want to hear about. So, Aaron? Why don't you explain first what is the problem and that we're trying to solve, and then we can talk about the case itself. Like, what has happened is, people say it's like travel bans. I thought they were about entry. I thought they, I'm already here. I need and I'm applying for citizenship. What does that have to do with any of this nonsense with travel bans? So why don't you talk a little bit about what the travel bans are, how they've just been expanded, and then this secret memo, which I guess is out now, maybe not, on there, and what's been happening around the country for people covered by that memo.
All right. So I believe the first travel ban that we're talking about was June, and then another in December that banned individuals from certain countries under that law that you had discussed earlier, 212F. And so 212F, like Greg mentioned, is a ban on entry to the United States. It's not 212F itself is not exactly a blank check, and there is little basis for the bans themselves beyond, frankly, I can say it here: racism and xenophobia, and that's what it is. But now they've taken it further with a memo that came out.
Well,
From
first of all,
US.
it was originally 19 countries, and then this week they doubled the number, more than doubled the number to 39. So it's important to know, and I've seen the figure that it's like 1 in 5 people around the world now are affected by this. So 1 in 5 people. So it's a pretty big number.
They're also narrowing the types of people who can be exempted from these bans. And now they've taken a step beyond that with USCIS issuing guidance saying that the processing of benefits application for people who are here from these countries is being paused indefinitely. And this is going to impact 485s. It's going to impact most 765s. It's going to
Naturalizations.
in 400s, yeah, naturalization. So 485s are the adjustment of status. I shouldn't talk in
He doesn't
form
want,
terms.
want you voting next year.
Yeah. And what is the basis for this, Greg? How are they saying that they can do this?
They're largely saying it's like, well, these are all discretionary, and we've made determinations because we put so much thought into these travel bans that we need to do all this extra vetting for these people, and that we're not actually saying we're not going to adjudicate these cases. So they are letting you file these things. We're just saying we put a pause on actually finishing up any of these cases while we do all this extra vetting to make sure that none of these people are planning anything. And they started. This is essentially stemming from that shooting in Washington a couple over Thanksgiving weekend, which was tragic, and it was involving one Afghans. I guess he was a special immigrant that had come here. So somehow that one person committing a crime is essentially enough to justify all of this, even though there are lots and lots of studies showing that immigrants are much less likely to cause harm to Americans than other Americans are likely to cause harm to Americans on there. But that's where we are. But that's how they justified it. And essentially, they're saying that, because this is like they're accepting the applications, meaning they're taking your money, but that I think honestly nobody really believes that they're going to lift this, and B, they will just continue sitting on these cases until a Democrat gets elected president. Is probably basically the way that it's going to go unless they're challenged.
So the obvious things that people probably think of first are, well, that means my application is not going to be granted. It's going to cause delay. And yes, that's all true. But sometimes I think people, when they first hear about this policy, they don't think about the other implications of it. So, for example, for as long as I've been practicing immigration law, so I guess 18 years now, and longer than that, when somebody had an application for adjustment of status pending, they were in a period of stay that was authorized, which gave them generally pretty solid protection against enforcement action. Mm-hmm. That is not the case anymore. So people are suffering enforcement actions while they have pending applications. So if you have a pending 485, but any underlying status is no longer there, are you vulnerable to ICE arrest and detention while you can't get your application adjudicated? The answer, I think, is yes. And of course, this is hugely problematic for people. There are other implications as well. And so we got together, we talked, the IMMpact group, and we just decided, what, this can't stand. We need to go right now, put together a case, and argue that the Administrative Procedure Act, for one thing, the Constitution for another, does not allow you to pick out 39 now countries and say, we're actually not going to work on their cases. We're not going to process their cases. And like Greg said, they're calling it a pause. But we know the types of people that are implementing this pause. And I don't believe, and I don't think anybody probably who's kept up with the issues believes that they're going to, in good faith, work to get started on these cases anytime soon.
Yeah, I will tell you, I had a consultation yesterday with a physician who is from one of these countries, and he had 5 different applications that are affected by this secret policy. He has a temporary protected status application that is for an extension for his category, which he's entitled to. He has an employment authorization document application that is tied to that. That's pending. He has he's seeking to change to H-1B status, which one can do from if they had legal status before they got into TPS, they can file to change to H-1B status. He has that application pending. He has been approved for a national interest waiver already, and has a adjustment application that has been pending based on that. That is affected by this. And he has an employment authorization document application that is tied to the adjustment application. All of these things.
That's an aside, Greg.
Are held up right now.
Can you tell people, just as an aside, what does it take to be granted a national interest waiver? Like, what does that mean that they have found about you?
They have found that you are doing work that is in the national interest of America on there. Which
so this,
it's sort of like when you have a government agency that it says it is in the national interest of the United States that this guy be permitted to not only come to the United States, but to stay here for the rest of his life. And then on the other hand, you say, but this other travel ban, supersedes, even though that ban is not about him in particular. It's about this broad group of people on there. That's pretty silly on there.
So this individual that you talked to, this is what the government found about them, that their presence and work is so in the national interest. But some person who probably had some kind of mental breakdown committed an awful crime.
Yeah.
And that means that all of this is thrown out the window for him and everybody else. And to be clear, I'm not saying that it's just the national interest waiver cases that are righteous. They're all righteous, but it just makes zero sense.
And this is a guy who's saving lives every day. So literally, if we look at sort of the net loss to in American lives, if this guy doesn't come here on here versus like the basis for the policy in the first place, there's like no comparing. I mean, it's ridiculous that we're having to we're having to litigate for this guy on there. But we also know that there's this fig leaf that the administration has called national interest exceptions, which they've they put in these in these bans. And as Aaron, have you seen a national interest exception approved?
Have they released guidance on how to get it approved?
Well, on the H-1B case, I know several, they did release guidance, but there's been 0 national interest exceptions for the H-1B ban. And as far as we know, there have been 0 national interest exceptions on the 39 countries bans on there. So that is that is something that, and not only that, but they're at least made some exceptions in the bans themselves for some categories where you didn't have to apply for a national interest exception. They said it didn't apply to you, and you just alluded to it a minute ago. The big one is they stripped out the exemptions for spouses of U.S. citizens. I think David Beer just posted on X that something like 100,000 people are affected by that one change alone in the way they've recrafted the bans for all of those people. And those people are welcome to be in our case if you're in that situation where you suddenly you thought you were exempt and now you're not. So that is that's the problem. And then sort of extending it to all these benefits, that's that's what our case is about. That the president does have some leeway to, because of the Trump v. Hawaii case, to issue some bans if he follows basically the case, Trump v. Hawaii, and does it exactly the way he's supposed to, and keeps it sort of narrowly focused along that lines. This is like way, way beyond what the Supreme Court had authorized in that particular case. And keep in mind, it took 3 times for the administration to finally get to the point where they had a travel ban that was surviving, and it was only because they followed sort of that level of specificity in there. But this is if they want to argue that they can prevent people from entering at a port of entry, that's fine. But basically, they don't have the authority to completely shunt aside Congress's entire system for administering the immigration system. It's a really major separation of powers question here. I mean, this gets to sort of the heart of the Constitution and the 3 branches of government and checks and balances, where the president can basically shut down the entire power that Congress has. It says in the Constitution, only Congress can set the rules for immigration. They delegated to the president in one narrow circumstance in 212F the ability to keep out individuals or groups of individuals if it was in the interest of the United States. But they didn't basically say in there that if the president wants to take all the power away from Congress and force Congress to actually have to, pass new legislation to stop the president. That's not what was meant by this. And so that's I think the most powerful argument in the case is that only Congress has the authority to do what the president's doing right now. So, Aaron, I guess this is going to be shaped as mandamus. Is that the strategy, you think?
Well, in part, I think there's just a pure APA piece to it, and that they're withholding a benefit or adjudication that the person is lawfully entitled to. So not only just an unreasonable delay, but also they're just saying that they're not going to give it, even though they're calling it a pause for now.
So there'll be APA claims. There'll probably be a mandamus claim. There may be a straight constitutional claim on the separation of powers, ultra virus as well.
And I'll tell you, I think what we can share for now is we are interested in moving quickly on behalf of plaintiffs who are ready to fight this. And because of that, I think as we bring on people, as we onboard people, we have not made every strategic decision yet. We do not know exactly which district court this is going to be filed in yet. We actually still are reserving the ability to group plaintiffs as we see fit, as we think makes most sense, in either one case or multiple lawsuits based on benefit or based on category. So there are decisions that we will make as the onboarding happens and as there are developments either in the law or in the policy released by the agency. But what I think is just that these cases aren't going to move anytime soon unless a court forces them to move them. And so I don't want to tell people to just wait and see or hold tight for a few months or hold tight for 6 months and see how this pause goes. I don't think that's going to work. And so that's why I am fully on board with this aggressive approach to get into court as soon as possible.
Yeah, so we're aiming to get our plaintiffs lined up by the end of the month. I think December 30th is the date that you'll find on the website. If you go to this page, or if you can't remember, you don't want to take a screenshot of this or write the whole thing down. Just go to IMMpactlitigation.com and you can see the onboarding cases. And on there, you'll see a frequently asked questions document that kind of lays out how the case is going to work, how you can be a plaintiff. We have some cool AI apps that we've developed as we've done for years to basically make onboarding easier as far as being able to create an engagement letter that you can sign. There's a question and answer process that will help you draft the sworn statement, also called a declaration, that you need to sign to be in the case, but we make it really easy. And then we will, I don't know if, Aaron, if we're going to do any private live streams for plaintiffs in the case, but we usually do one or two of those before we file. And then after we file, that's also how we keep in touch with our plaintiffs without necessarily having to broadcast to the entire world.
Yeah, I think that's likely. I did want to address some question from Sahar.
Yeah,
Sahar, I
I'll
can't say
put
it
that
all.
on the screen.
So it says, oh no, the next one
Oh,
is
sorry.
it says if we're litigating about somebody's 485 and it gets lifted, will the I-765, so that's the work permit application, will that also be lifted, or is a new litigation needed? And I can say, like I just said, we haven't made all decisions yet, but I can confidently say we're not going to file a lawsuit on your behalf that's only about the 485 if there's also a dependent 765. So that will be included. We'll be working to get both of those going.
And we will list for each of our plaintiffs, each application that they have that's pending, so that all of them are covered. So we'll have plaintiff paragraphs for each of you that are going to specifically list that I have this filed, I have this filed, I have this filed, so that everything's covered and not just sort of the high level one. I don't know if we have any other ones here that you want to mention, but I don't think that I know Chuck and Jesse were on last night, so they probably talked about some of this stuff last night too. But we did want to give do another one of these tonight, and also talk about. We knew we were going to have this news on the H-1B case today as well, which is another reason why we wanted to repeat. So I think we can probably end there. But like I said, if this recording will be available. Oh, we have another question. I'll put that up in a second. This recording will be available on X. It'll be on LinkedIn. It'll be on Facebook, on YouTube, and other places where you can watch it. So let me. I posted 3. Oh, Zara had. Could you please answer my question above? This was the question. Are you going to discuss the Cook litigation against the pause on adjudication? That's what we just talked about. Now it's 39 countries, not 19, but that's what we've been talking about, Zara. So yes, that's what and that's what the link that I just showed you is for. But that's the, if you were if you were thinking you were going to be in that case for 19 countries, this is the same case. Okay, we had, you understand USCIS needs names and details of plaintiff. Will your name be on the court doc? So one of the issues that we dealt with this, like in the student case, where we had we had pseudonyms. That is an issue we will consider. You will not, and we'll probably do that, just because it's there are obvious reasons why you don't want to. Want to have our plaintiffs' names out there. So pseudonyms are basically where we say John Doe 1, John Doe 2, and we basically have the people, our plaintiffs listed, but not with showing their names on there. And then the judge will basically, you have to make motions on that, and we have to get permission. And then if the judge says no, then we would give people the opportunity to leave the case if we couldn't have them in anonymously. So that's that's a good question, and that's probably what's going to happen. We'll have more information on that probably soon, but I will tell you that is we've just done that in the case that we filed in Boston for 150 plus students. We did that in our Georgia case with 300 or 400 students, 400 plus students that were in that case, and we got the results we wanted without having to reveal our plaintiffs' names publicly. So I would expect that to happen in this case as well. And we actually, in our case that we filed, the H-1B case in San Francisco, Global Nurse Force, we have Phoenix Doe, who is a university researcher, who is one of our lead plaintiffs, lead individual plaintiffs in that case, and that was done under a pseudonym. Her name is not Phoenix Doe; it's something else. But that is that I would expect is going to happen again. Aaron, you want to talk a little bit about like how timing works on these cases?
Yeah, sure. So I think the short answer, do we have an estimate of when there would be initial court results? The short answer is no. I think anytime that you're hearing a promise about exactly when results can be seen out of litigation like this, you want to take a pause because it's actually not in the lawyer's control. But we can talk about our experience in cases like these and what it looks like. So after we file the complaint, the government has generally 60 days to respond, and they will respond with either an answer or a motion to dismiss. At the same time, we often see, and I don't know whether to expect to see this in a case like this. I think no, but we often do see our plaintiffs start to have their cases move just from the litigation having been filed. I don't know what you think, Greg. I don't think they're going to do that here.
It's hard to say. They might want to moot out a bunch of people. We're not filing this as a. We're not going to be doing this. Well, we haven't made decisions yet regarding the class, but even if we do it as a class, it takes a while to get to that point. Sometimes strategically, you may remember some conversations in the Ukraine case where the government tried to talk one of our plaintiffs into a quickie settlement on there in order to try and destroy the case by getting rid of our named plaintiff. But so sometimes that happens, but in all likelihood, I don't think we're going to see that. But I guess the question is also in terms of interim relief, like for an injunction or a temporary restraining order, that does change the timing somewhat. Maybe you can talk a little bit about what, we haven't made any decisions yet on what would be filed, but let's say we were going to do a preliminary injunction. How does the timing work with a preliminary injunction motion?
So, preliminary injunction is basically seeking some relief while the case is pending. And there's four factors that you have to show go your way to get that. And one of them is that you're likely to succeed on the merits of the case. And then they talk about harms to the plaintiffs, harms to the defendants in it. But if you can show those things and you can file for the preliminary injunction, you can get some relief more quickly. I still think like you're probably more interested in how many months after this, and frankly, it's at least months. I don't think there are cases where we file and we start to see results for our plaintiffs in weeks. That's not my expectation here. But like I said, I just don't want to make promises that are faster than that because court cases take a long time and we don't have the control of it.
Yeah, I mean, we will seek to get things moving as quickly as possible by the judge. So it's not like we're not going to be asking for our plaintiffs to get relief as quickly as possible. We just don't want to make promises that are out of our control as far as how quickly our judge is going to act. We don't want to make promises about whether we're going to win the case or not. That would be irresponsible for any law firm to make that kind of promise. I can tell you, Aaron, I don't know how many we've done. I think we're over 40 of these mass cases against presidents over the years, and we have a pretty good record on there. But I'm not going to. We would not. We always say there is no guarantee on whether we're going to succeed or not. I'm not sure. Did you see the question from MM? I don't know if I want to put that. Do you understand that question?
I think it was about the pseudonyms.
No, this was this. Oh, yeah. Is that? I'm sorry, I
So
didn't realize they were connected.
if they denied to allow our plaintiffs to litigate under pseudonyms, can that be challenged in court? I think that's what it was about because it
Yeah,
just
no,
I
she
don't
asked.
want to
I
answer the
think she
question.
asked the question maybe on there, but the in that one, in that case, basically, if we lose on that, the names don't get revealed. We would have the ability to basically withdraw all those people who wanted to only sue under a pseudonym. We would have the ability to take those people out rather than their names
Right.
becoming public. Um,
Right.
so this is actually so somebody's saying they're talking about the after the new countries were added. I did, Aaron. I'm going to show the web page just to
Great.
and share that for a second on here. So this is the you see it, Aaron?
Yep.
Okay, so this is the web page we were just putting up online. It is all updated now to have all 39 countries on here. So basically, it starts out with a kind of a summary of what the case is about, and then we. This is important. If you want to be in the case, we have an FAQ, which just didn't load. It went into my download folder, but you'll want to read that. It's sort of like a lot of questions and answers about how the litigation works. You would go here to create your engagement letter and as well as your sworn statement. We do these cases. Some of them we do pro bono, like the H-1B case we're working on is pro bono. Some of them we are, especially when it's not really for everybody. We estimate what our budget would normally be for the case, and then we would charge on a per plaintiff basis for that. So that's all here. And then I think that's it. But basically, you can find everything you need to find out at the at the at that web page.
So that I was just going to say for that last question, we have seen, unless I missed it today, I was very busy today, but I haven't seen an updated USCIS memo that adds in the rest of the 39 countries. But I have seen colleagues who have already reported that, for example, their oath ceremonies for people from the new countries have
Yeah,
been canceled.
that was the first thing I heard is that those people were pulled out of line from the new countries and were not allowed to get sworn in today, which
So
is
we have every expectation that the new countries are also going to be included in that memo. Of course, they will in a new memo. Of course, they will be. And so, yes, we are accepting plaintiffs on that, even though USCIS hasn't
yeah.
published it.
That's what the question. I didn't understand the question. You understood the
Yeah.
question better. So, thank you. Sorry about that, Rami, but I'm glad that Aaron reads better than I do.
Then we have two questions that are look very related. One is from Mason, and one is again from Zara. The first is, can people join this suit later, like 6 months later, once they have something pending? The answer is maybe. We don't know. It depends, like what stage the litigation is in, whether it's possible to add plaintiffs, and it may well be, or it may not be, and if not, then we may be filing another one. So.
Yeah.
Um, Definitely
That was
worth
the
reading.
for the yeah, that was the case for the travel bans, but in the first Trump administration, where we had to file multiple cases in sequence because we couldn't keep our plaintiffs waiting for another group to be coming later on, and we there's a limit to how much time you have to amend a complaint and add additional plaintiffs. So, in which even adding additional plaintiffs that causes some delays too. So we try and be careful about doing that too much. But that's the if there's still a lot of if this problem hasn't gone away and we're still dealing with it, then we'll keep suing. It's the bottom line on there. So Mason, don't just keep attuned. I'm trying to see what.
Next,
No, he's a charger. That's okay. I'll forgive him.
you got you got your the
Which
next
one?
one is Zara,
Okay.
and then this one is similar, but it's about the same person. So you're already a plaintiff, and then there's a new application that becomes pending that you file while the litigation is pending. And I would say that if it's possible to get your new application into the lawsuit, for example, through an amended complaint, If we're amending the complaint, we'll add that in for you, and there won't be like an extra charge or anything for that. But it's not like at every stage of the litigation, it's not always possible to amend the complaint. So it's hard for me to promise that we'll get future petitions in. We'll do our best. I don't know, Greg, what do you want to say about that?
I mean, one thing I can tell you, sort of when we get down to moot, the government wants to moot out plaintiffs usually once these cases are going and the judge is putting pressure on them. And we can sometimes negotiate on an individual basis, things like that, which is, this is a very reasonable thing to ask DOJ lawyer for, if we're actually at that stage, to say, look, this person is now at a point where they can file this petition, and we want to have that also covered by this. If you're going to expect us to dismiss that plaintiff on there, so that's also part of it. Is that there's not we can't give you a firm answer on that, although we've had some success for making those kinds of requests in the past. You're smiling. You see a question you want?
Yeah, a couple more. So Maji C, 658.
Okay.
I think we'll get to two more. Great question. One of the concerns is that if the court lifts the pause, they could get annoyed with the negative factor of the country of origin. What would be your strategy if we face this issue? Really good question, and really important time for us to say, hiring us to file this litigation does not make us your lawyers in front of the agency, like USCIS, on your actual application. What that means is that if you get annoyed, you're going to be filing that with your individual lawyer. You could hire one of us individually, but it would be separate from this litigation, right? And so I'm sure we would have thoughts on ways to.
I think you'd have a really strong case, probably, if you were challenging that in court separately. And my guess is that the USCIS, after you've just been successful, where a judge just ordered them to work on the case, they're not going to be super excited about basically insulting the judge by then going ahead and trying to get a workaround. They might, but I'm saying that it's not going to look very good with the judge when you go back to the judge saying, hey, this was how it was handled. We just basically proved that and country of origin should not be a negative factor in making a determination on whether to adjudicate these cases. And then they go ahead and do that.
Yeah, and to be clear, I should have been more clear. Like, I anticipate, like I said, we haven't made every decision yet on this, but I anticipate that part of the relief that we are asking for is that they can't use this as a negative factor in the adjudication.
Aaron, why don't you talk about a little bit about kind of like the settlement on the student's case? Because I think that is similar on this, where, for example, we said, like, you can't use this as the basis for putting somebody, like, when you reinstate their CVIS, you can't then go ahead and turn around and say, now we're going to file a note, on the same basis that we withdrew the CVIS, put you into removal proceedings, for example, or do these other things. And we were able to get all of that in a settlement. That is something that we either will ask the judge in an order to prevent that from happening, or we will get it in a settlement from you with USCIS and State Department on there. Right. So what I'm thinking is that on there's two different questions here. There's one question about forcing the government to make a decision, and then the question is whether they still go ahead and make that a factor in issuing a negative decision. They're different things, and it may be, Aaron, that we end up addressing that in the complaint itself, saying that where not only are we asking them to make a decision on it, but they can't say we're going to make a decision and use this as a negative factor. So I think that's a really good question, and actually it probably is one that I think we might be able to head off in the complaint itself by asking a judge to prevent that from happening. But I think, Aaron, what you were getting at is they could still deny the case for things that are completely unrelated. Like some people say, this is sort of the mistaken belief with mandamus cases, which is if you win a mandamus case and the government's forced to make a decision on a case, doesn't mean you're going to get the decision you want. It just means you're going to get a decision on there, and that will sometimes happen. Or if you have a lousy case for a an I-140, for example, that's discretionary, and and it's just sitting there, and you get this order that USCIS has to adjudicate. That doesn't mean that they're going to give you the decision you want on the I-140 if they decide that you're not all that extraordinary or you're not really doing anything in the national interest. So that's, I think that's important to note about what this litigation can do, and is going to have no impact on. And it's not going to have any impact on things that are unrelated to the travel bans.
I will also say that speculating wildly here, but as if some of you are following the orders that are coming out of federal litigation of all kinds in the immigration sphere, habeas cases, things like that. To me, that some of the language from the judges is getting more and more strident and kind of exasperated by the types of games that DHS has been playing. And in some ways, in the right court, I think that can work in our favor. And I do not think that they will like if they make an order and then they're trying to work around it. And so, we'll be sure to address it.
Yeah.
I know that we're wrapping up here. The last questions that I'll address in rapid fire here: what are the trade-off between litigation between all types of benefits versus litigation on one type of benefit? Not making those calls right now, not making decisions right now. Just as a little bit of background, we would say they have a mandatory duty to adjudicate all benefits. So that's mandatory. That's not discretionary to make a decision. It might be discretionary about what the decision is. But different benefits have different statutes and regulations behind them. And so, for example, that N400 is not a discretionary benefit. The 485 is. And so will it make sense to have different cases for those or other benefits? We haven't made that call yet. But so those are some of the considerations we'll be taking into account. Probability of success, next question.
I think on any time when you sue the Trump administration, you start out with like a little bit of a probability of success, just because they are really bad at following the law in general. So, you can't control who's going to be the judge in the cases. You can't control various things, but we wouldn't be taking this case if we thought that this was just it was just a policy we disagreed with, if we didn't think there was actually like strong legal arguments to go against it. So we're not going to, we're not going to give you sort of like prognostications on percentage chance of winning here. I think that any law firm that says, oh yeah, this is a slam dunk, you should probably run away as fast as you can from working with them. I think you always need to assume that litigation is a slog, and that there's there's always a significant chance it's not going to go the way you want. As far as strategy, on there, I think some of it, we have more details in the on the webpage and in the FAQ as far as that. Some of the strategy, like Aaron said, we're having meetings, we're working on that, we're making decisions on how it's going to be. It's possible we could split the case up in different ways. It's possible that there's a variety of arguments that we make. You can't make every single argument. You have page limits for one thing, as far as what you can do, but we'll have more to say about that. And I think you can probably look at also some of the cases that we've worked on in the past on similar issues, and you'll see, a lot of the different kinds of arguments that we've made. Keep in mind, we have done many travel ban suits at this point that were on, a very similar issue. Like we sued about visa issuance at least a half a dozen times. And that's similar to this, where basically 212F bans an entry, but it doesn't allow all these other things to happen. And one of the things it doesn't allow to happen is is failing to issue a visa, and that's very analogous to this. So you can look at some of those cases and see some of the arguments that were made in our like the Milligan case and others. If you want to get a flavor for what are some of the arguments you can make against an administration that's trying to do this kind of thing. Aaron, is that it?
Last thing as I say goodbye, I'm just hitting them. This is the last one for real. Mia says, if I'm understanding quote correctly, you don't expect plaintiffs to receive noise based on country-specific factors. No, I don't know that. But that'll be part of our ask that the judge rule that they can't use the memo in that way.
Yeah. So that's that's kind of the point of this, is to cut them off on all the tricks that they might try and use to make this policy remain effective. And hopefully a judge will agree with us that if they agree with us on the one, that they're not going to allow them to work around it by doing that kind of thing. So hopefully we'll make our arguments well with the judge, and we'll get somebody that actually wants to follow the law. And I'm optimistic that, as Aaron said, I think a lot of the judges are paying a lot of attention to these issues and treating them really seriously when the administration does this kind of thing. All right, it's late. We will conclude. Hopefully we have been helpful tonight, and stay tuned. And we'll be back shortly. I'll be back next Wednesday night's Christmas Eve. I'm totally not going to be doing a live stream next week or the next week, which is New Year's Eve on there. So I don't know, maybe I'll switch to daytime for the next 2 weeks. We will see. Aaron, is great as always to talk about with you, and we'll be back soon.
Thanks all.
Thank you.